Discuss what is Memorandum of Association. Memorandum under Companies Act 2013. Now I will take you to Companies Act 2013. We'll go to Google, type mca.gov.in. Go to Ministry of Corporate Affairs. This is official website. Then go to Acts and Rules, Acts, Companies Act 2013. Then here you can see first chapter is a preliminary. Chapter 2 is incorporation of company and matters incidental thereto. Click here. Then here section 4 is a memorandum. Section 4 is Memorandum of Companies Act 2013. See the Memorandum of Company shall, the name of the company. So what the memorandum contains? So first, the name of the company with the last word limited. Limited in case of a public limited company, at the last words private limited in case of the private limited company. So the last word of the name of the company, if it is a public company, this is a limited. Limited means it's a public limited company. If the last words are private limited, then that is a private limited company. Sri Venkateswara Private Limited Company. Sri Venkateswara Private Limited. So that is a private limited company. Sri Venkateswara Limited. So that is a public limited company. So there is a difference. The name of the company with the last word limited in case of the public limited company, or the last word is a private limited in case of the private limited company. Provided that nothing in this section shall apply to the company registered under section 8, because section 8 company you cannot find limited or private limited. So this is not applicable to section 8 company. Section 8 company, the last word comes like association, foundation. So the state in which the registered office of the company is to be situated. So the memorandum of association contains the name of the company and the state. The state in which the registered office of the company is to be situated, like Telangana, Andhra Pradesh, like the state. State in which the registered office of the company is to be situated. Objects for which the company is proposed to be incorporated, and any matter considered necessary in furtherance thereof. So the memorandum of association contains first name of the company, then registered office address, and the state in which the registered office the company is to be situated, and the objects of the company proposed to be incorporated, and any matter considered necessary in furtherance thereof, and liability of the members. Liability of members of the company, whether limited or unlimited, also state in case of a company limited by shares, that liability of members is limited to the amount unpaid, if any, on shares held by them. So the liability of the shareholders is to the extent of their subscription. In case of a company limited by guarantee, so the amount up to which each member undertake to contribute. So whatever is the guarantee is given. So at the guarantee, see, to the assets of the company in the event of its being wound up while he is a member. Suppose the company is limited by shares, okay, it's very clear. To the extent of their subscription, shareholders are liable. If it is limited by guarantee, so all these things has to be mentioned in the memorandum. That is what we are explaining. What memorandum contains. So memorandum contains the name of the company and the state in which the registered office of the company registered, and the objects of the company, and matter considered necessary in furtherance of the objects. And next, liability clause. If the company limited by shares, the shareholders are liable to the extent of their subscription. If the company is limited by guarantee, then the amount up to which each member undertake to contribute, they are liable. So how long they are liable? If the company is wound up while he is a member, or within 1 year after he ceases to be a member, even after resignation also, up to 1 year he is liable for payment of the debts and liabilities of the company, if any, or such debts and liabilities as may have been contracted before ceases to be a member, as the case may be. So even after resignation also, the shareholder is liable if the company is limited by guarantee. The period is 1 year. The liability in case of limited by guarantee, the amount which each member undertake to contribute to the assets of the company in the event of its being wound up, while he is a member or within 1 year after ceases to be a member for payment of debts and liabilities of the company or of such debts and liabilities as may have been contracted before he ceases to be a member, as the case may be. So this explanation is in case of a company limited by guarantee. And to the is liable, they are liable to the cost and charges and expenses of winding up and for adjustment of the rights of the contributories among the individuals. These are all in case of that company wound up. These are all company limited by guarantee. In case of a company having a share capital, the amount of share capital with which the company is to be registered and the division thereof into shares of a fixed amount and the number of shares which the subscriber to the memorandum agreed to subscribe which shall not be less than one share. Suppose the paid up capital is 1 crore. So even take 1 lakh rupee. 1 lakh rupee and each share price is 10,000. Each share price is even take 10 rupee, minimum 10 rupee. So for 1 lakh capital, each share is 10 rupees. So 1 lakh divided by 10 is 10,000. 10,000 shares into 10 rupees is 1 lakh capital. 1 lakh capital. So the amount of share capital, that is paid up capital, will be divided as per the shareholding. It will be divided to the shareholders as per their shareholding, which shall not be less than 1 share. So according to their shareholding, they will invest in the company. Suppose 100 shares, 100 into 10,000 rupees, shareholder will invest. The number of shares each subscriber to the memorandum intend to take indicated opposite his name. In the memorandum of association, it is clearly written the shareholder name, the subscriber name, and how many shares he is subscribing, at what price he is subscribing, what is the face value. It is clearly mentioned. Opposite his name, number of shares also will be mentioned in the memorandum. In case of 1-person company, the name of the person, in the event of death, the subscriber shall become the number of the company. So he has to nominate if it is a 1-person company. And the name stated in the memorandum shall not be identical or resemble too nearly the name of an existing company. So if the name already there in the market, so even if you apply also, MCA will reject because same name will be rejected. And if the name constitute any constitute an offense under any law for the time being in force, it will be rejected. At the time of name application for name reservation itself, it will be rejected. Even if it is an undesirable name, in the opinion of the central government, it will be rejected. And without prejudice to the provision, subsection 2, that is what we discussed, company shall not be registered with a name which contains if the name contains like any word expression which is likely to give impression that the company in any way connected with or having patronage of central government in the name, if it is a central government, state government, local authority, corporation, or body constituted by the central government or state government or any law for timing in for these names will not be getting. You can't see in the name central government or state government like local authority names. These names, even if you apply, also central government will reject. So such words as may be prescribed unless the previous see if the particular name MCA will suggest you take prior approval or you take approval of RBI, then it will be accepted. Otherwise, these names, if it is already there in the market, the same name you will not get it. If it is undesirable name, you will not get it. So at the time of application for name reservation through run form, so we have to be carefully check whether the name is already available. A person may make an application and accompanied by such fee as may be prescribed to the registrar for the reservation of the name. It is 1,000 rupees. So 2 names can be applied in one form and by paying 1,000 rupees to MCA, online payment. Here, there we have to mention the proposed names. The name which the company proposed to, even if the for name change also we can apply proposed name change. Already one name is there. If you want to change the name of the company, then you have to apply for a name application for name change by paying 1,000 rupees. Upon receipt of the application, the registrar may, on the basis of the information and documents furnished along with the application, MCA will reserve the name. If it is for name reservation, it is the name for incorporation of the company. Name will be reserved and time will be given for 20 days. Within 20 days, the company has to be incorporated. And if it is not incorporated within 20 days, then again we have to pay some additional fee and we have to further extend. Otherwise, it will be expired. In case of application for a reservation for name change, already existing company applying for name change, the name will be reserved and time will be given 60 days. Where after reservation of the name, it is found that the name applied by furnishing a wrong or incorrect name. So if MCA found later that the name applied is a wrong, furnishing wrong information or incorrect information, then the company has not been incorporated, then it will be penalized with 1 lakh rupee. If the company is incorporated, then registrar may, after giving the notice to the company, direct the company to change its name within a period of 3 months after passing on ordinary resolution, or ROC take an action for striking up the company from register of companies, or make a petition for winding up the company before NCLT. So the memorandum of the company shall be the respective form. Anyway, it is a prescribed and specified form. Under Schedule 1, it is mentioned. Any provision in the memorandum on articles in case of the company limited by guarantee and not having a share capital, purporting to give any person a right to participate in divisible profits of the company, otherwise than a member shall be void. So this situation will not arise because very rare, we never found the company limited by guarantee. Generally, company limited by shares are available in the market. This is what the memorandum under section 4 of Companies Act 2013. It contains the name of the company and address, state in which the registered office of the company is situated, objects of the company, and for in the necessary matter considered necessary objects in furtherance of the main objects, and liability clause, capital clause. So these are all given in the memorandum of association of the company as per section 4 Companies Act 2013. Hope you are clear. Memorandum of association of the company. Thank you.